Welcome to our CFP exam prep discussion on essential estate planning documents. Today, we're diving deep into the fundamental documents that every financial planner needs to understand thoroughly for the exam and real world practice. Let's start with wills, which are often misunderstood on the exam. A will is a legal document that directs the distribution of assets after death. But here's what many candidates miss. A will only controls probate assets, not jointly owned property or assets with beneficiary designations. The exam frequently tests this distinction with questions about property passing outside of probate. Remember that a will becomes effective only at death, not during incapacity, and must go through probate to be valid. A common mistake students make is confusing holographic wills with nuncupative wills. A holographic will is handwritten and signed by the testator, while a nuncupative will is an oral will made on deathbed. The exam loves to test these distinctions, especially regarding state recognition and validity requirements. Moving on to durable power of attorney, this document is crucial for managing financial affairs during incapacity. The word durable is key here. A regular power of attorney terminates upon incapacity, but a durable power of attorney continues through incapacity. The exam often presents scenarios where candidates must determine whether an agent can make specific financial decisions. For instance, if someone becomes mentally incompetent, only a durable power of attorney allows their agent to continue managing their finances. There are two types of durable powers of attorney that frequently appear on the exam. A springing power of attorney becomes effective only upon incapacity, while an immediate power of attorney takes effect as soon as it's signed. Test questions often focus on timing and triggering events for these documents. Advanced medical directives are another critical component that includes both living wills and healthcare powers of attorney. A living will specifies end-of-life treatment preferences, while a healthcare power of attorney designates someone to make medical decisions. Many students confuse these two documents. Remember that a living will is specifically for end-of-life decisions, while a healthcare power of attorney covers all medical decisions during incapacity. Here's a practical example that often appears on the exam. A client has a stroke and becomes incapacitated. Their living will wouldn't apply because it's not an end-of-life situation, but their healthcare power of attorney would allow their designated agent to make medical decisions. The exam frequently tests these scenarios to ensure you understand the scope of each document. One of the biggest traps in exam questions involves the revocation of these documents. All these documents can be revoked while the person is competent, but revocation becomes impossible once capacity is lost. The exam often includes questions about attempting to revoke documents after incapacity. To solidify your understanding, think of these documents as three pillars of protection. Wills protect assets after death, durable powers of attorney protect finances during life, and advanced medical directives protect healthcare decisions. Each serves a specific purpose and timing, and understanding these distinctions is crucial for exam success. Remember that state laws vary regarding the requirements for these documents, but the exam typically focuses on general principles rather than state-specific details. Focus on understanding the core purposes and limitations of each document, and you'll be well prepared for this portion of the CFP exam.